Assalamualaikum warahmatullahi wabarakatuh. Hello, my name is Rizcha Mustamilinda, NPM 201000360 from Class H. Here I will present the presentation of the material of criminal law. Criminal law, the body of law that defines criminal offense, regulates the apprehension, charging, and trial of suspect person, and fix penalties and modes of treatment applicable to convict on offenders. Criminal law is only one of the devices by which organized societies protect the security of individual interests and ensure the survival of the group. There are, in addition, the standards of conduct instilled by family, school, and religion, the rules of the office and factory, the regulation of civil life enforced by ordinary police powers, and the sanctions available through tort action. The distinction between criminal law and tort law is difficult to draw with real precision, but in general one may say that a tort is private injury where a crime is conveyed as an offense against the public, although the actual victim may be an individual. Next, principle of criminal law. The traditional approach to criminal law has been that a crime is an act that is morally wrong. The purpose of criminal sanction was to make the offender give retribution for harm done and expiate his moral guilt. Punishment was to be meted out in proportion to the guilt of the accused. In modern times, more rationalistic and pragmatic views have predominated. Writers of the Enlightenment, such as Seneca Beccaria in Italy, Montesquieu and Voltaire in France, Jeremy Bentham in Britain, and P.J.A. von Weierstrass in Germany considered the main purpose of criminal law to be the prevention of crime. With the development, the main purpose of criminal law to be the prevention of crime. With the development of the social science, there arose new concepts such as those of the protection of the public and the reform of the offender. Substantive criminal law. Substantive criminal law is composed of the following elements: the definition of the types of offenses that are held to be punishable, the classification of crimes as, for example, felonies and misdemeanors in the United States, or crime, delicts, and contravention in continental law. The principle and doctrine applied to the judgment of crime that qualify the provision of criminal legislation, and principle determining national jurisdiction over crimes with an international aspect. Crimes committed by foreign binational aboard or on ship and aircraft outside the national territory and waters. Next, the definition of criminal conduct. Legality. First, legality. The principle of legality is recognized in almost all legal systems throughout the world as the keystone of the criminal law. It is employed in four senses. The first is that there can be no crime without a rule of law, thus immoral or antisocial conduct not forbidden and punished by law is not criminal. The law may be customary as in some common law countries. In most countries, however, the only source of criminal law is such statute. Second, the principle of legality directs that criminal statutes be interpreted strictly and that they not be applied by analogical extension. If a criminal statute is ambiguous in its meaning or application, it is often given a narrow interpretation favorable to the accused. Third, the principle of legality forbids the application of the law retroactively. In order that a person may be convicted, a law must have been in effect at the time the act was committed. Fourth, the language of criminal statute must be as clear and unambiguous as possible in order to provide fair warning to the potential lawbreaker. In some countries, statutes may even be considered inapplicable if they are vague. Next, protection against double jeopardy. Legal systems generally include some restriction against prosecuting a person more than once for the same offense. In Anglo-American law, the most difficult problem of double jeopardy involved the question of whether the second prosecution is for the same or a different offense. It is held that acquittal or conviction of an offense prohibits subsequent prosecution of a lesser offense that was included in the first. A problem under the federal system of the United States is whether an offender may be prosecuted under both state and federal law for the same conduct. A number of state laws have prohibited state prosecution after acquittals or conviction in a federal court or in the court of another state for offense involving the same conduct. However, the U.S. Supreme Court has held that such multiple prosecution by separate sovereigns are not prohibited by the double jeopardy clause of the Fifth Amendment for the U.S. Constitution.